Everybody to what we call a movement center, which is where you are. It's a multi-purpose meeting space for progressive organizations. And I want to bring greetings from our CEO, Deborah Scott. Deborah Scott is the CEO of Georgia Stand Up, Georgia Trade Up, Georgia Build Up, and We Vote, We Win. We Vote, We Win is a 501c4 nonprofit that is working in the community to register voters, voter engagement, as well as voter turnout. And so with that, I do encourage you to tour the building a little bit. We have a fashionable building, and Ms. Shepherd here, our hospitality director here at the Movement Center has done what you see is a yeoman's job of putting this space together and offering it to progressive organizations. You should know that this is available for progressive organizations to have meetings. There's space here that is sometimes available if a progressive organization needs office space, a phone, a printer, or a project of a week, a day, a month, maybe even a year. Check with us, because we can often arrange something. So I'd like to give Ms. Shepherd just a moment.
Thank you, and welcome to Georgia Stand Up, and you're enjoying the Movement Center. As Mr. Scott, and I have two titles. My title is Hospitality Coordinator, but my main title is being Mr. Scott's mother-in-law. So, I might as well get it off the top. But this space has been created as a movement center, and how we like to position it as where history meets progress. So on the wall, you'll see historic pictures and iconic figures that have made history in the civil rights era and for support for movement. But you can come here, get inspiration from those people who have done things before, and make the progress and move it forward. Our tagline also is stand up. When our rights are under attack, we stand up and fight back. And so Ms. Scott and Mr. and Mrs. Scott make that happen all over the state of Georgia and across the country. And so as he mentioned before, the space is a 10,000 square feet space. It's multi-purpose. So as you see this room, it can change in any format that you need it. Temporary or for project use as he remembered it. So I know this is the first time, but I hope it's not your last. So any way that I can help you make your visit more comfortable and progressive, let us know. Thank you.
All right, so ladies and gentlemen, esteemed guests, distinguished panelists, I want to thank you and welcome you all here this afternoon for the Legal Planning Forum. This is a W.C. Thomas, Lodge number 112 production. We operate under the leadership of Worship Master Raphael Holloway, who is present here today. My name is Brian Ross. I'm a judge in the DeKalb County State Court, and I'll be serving as your moderator. We're very pleased that you're all here to join us because estate planning, I think at this point we all realize, is critically important. It's often considered complex and daunting, but it's really one of the most important endeavors that we can participate in as adults. We need to be cognizant of our requirement to safeguard our assets, look out for our families, our spouses, our children, and unfortunately many of us don't think about it until it's too late. So by providing this panel here today, we hope to give you the tools and resources you need that will allow us all to avoid making that mistake. Here today, we're going to focus on a number of things. Wills, trusts, estates, and the probate process. What happens if you die without a will? What are the laws that govern what's going to happen to your estate? What happens if you have a blended family, as many of us do? that can create a lot of issues. It's best to be proactive and get in front of these issues rather than wait and see what's going to happen on the back end. So I want to thank you all for being here today. At this time, I'm going to ask the participants to introduce themselves. They're both very distinguished members of the board, as well as practicing attorneys. So we'll start with as Master Imani Clark.
Good afternoon, family. My name is Imani Clark, and I am pastor outside of Gate City Lodge on the 42 standard. I practice law in Stone Mountain with my wife. Her name is Chanel Clark. She is right over there. She always says, I do not introduce her. This is an introduction for her. We do have a general practice. Our practice consists of estate and probate, immigration, personal injury, and divorces.
Thank you.
Good afternoon, everyone. My name is Stephanie Shepherd. I'm a sister from Daughters of Barnesville, number 465 in Barnesville, Georgia. I am the principal member of Shepherd Legal Services, LLC, a boutique law firm in Atlanta, Georgia. And I practice primarily in estate planning and probate, do some bankruptcy work as well. I'm also certified as a mediator. But like I said, this is what I do.
Let's welcome our panelists. So essentially, we're going to open it up for questions and answers. We're going to give each panelist the opportunity to make a presentation. If you have a question during the course of the presentation, don't hesitate to raise your hand and ask. We'll recognize you, give you that opportunity. Because sometimes if you wait till the end, you forget what you want to ask. Right? We're going to let Attorney Clark go first. He has another engagement later this afternoon. So we'll let him go first. And again, he'll take questions during the course of the presentation. Then we'll ask Attorney Shepherd to do the same. So this is a really, you should feel free to ask anything that you want about the issues that are presented here today. But we do ask that you not be so specific in your questions that you go into your personal situations. Because although they are attorneys, the way attorney-client privilege works, if you discuss something with your attorney, it's privileged. In other words, they can't disclose it. But if you discuss it with someone other than an attorney, like this whole audience here today, then you've given away that privilege. So we can speak in terms of hypotheticals. I'll ask a lot of questions myself that may relate to some of your circumstances, but just please be cognizant of that and ask any questions you might have. All right. Attorney Clark.
All right, so I have a PowerPoint presentation that we can do it right here. I also have everybody in the room should have gotten an outline. If you do not have an outline, there are outlines on the back table and also pens and my contact information. All right. How many people in this room have a will? Raise your hand. Okay, that's great. Great. How many people in the room have a estate plan in place? Raise your hand. Okay, that's a good amount of number of folks that have it. Now, one of the reasons why some of us do not have a will or estate plan in place is because we always say that we're going to get around to it. And sometimes we just never get around to it, right? We live in a world where it's just going quickly, everybody's working a 9 to 5, and we state we can get a will in place next week. Sometimes that next week never comes. Because a lot of us are dealing with health elements, dealing with heart issues. Sometimes we're having dying of strokes, heart attacks, cancer, all these issues, and we still do not have a will in place or an estate plan in place. Now, who needs a will? Everybody. Now, I was reading an article the other day, and it stated that 32% of Americans have wills. Right? It used to be 42% of Americans. Can you hear me? It used to be 42% of Americans, they stated, that have wills. Is that better? Okay. I thought I was loud enough, but apparently I'm not. So I was reading an article, and this article said that 32% of Americans have wills. It used to be 42% of Americans that have wills. So that means that percentage is going down. But the article also went on to state that according to Black Enterprise, that 70% of African Americans do not have a will. Right? And it went on. So why we're here today, and you have to see the percentages right there. We're here today to figure out how we're going to pass on our wealth. How are we going to leave a legacy for our children? And you do these things by having an estate plan in place, and you also do these things by making sure you have a will or a trust. Now, when we think of some of our celebrities, you know, we have high regards for them. Bob Marley, we think of Prince, Elijah Muhammad. We think these folks must have had a will. They passed away, and they did not have a will in place. So it's quite believable why 70% of African Americans do not have a will. So, or an estate plan in place. So we're here today just to pass on some knowledge to you, to make sure that you can speak to your neighbors, make sure you speak to your children, make sure you speak to your family members, and tell them the information that we're discussing here today. Now, estate plan foundation is generally going to consist of a last will and testament. It's also going to consist of a statutory durable power of attorney, and it's going to consist of a Georgia Advanced Directive of Healthcare. Now, that last one, sometimes you'll hear a medical power of attorney, and you'll hear a healthcare directive. Just know that in Georgia, they've combined the two, and it's named now a Georgia Advanced Directive. And depending on your circumstances, if you have minor children, or depending on the facts going on in your life, you may also add a trust to this foundational plan. Now, once you pass, what happens to your assets? How do they pass? There's four ways generally. One is generally through a testate law, where the law tells you how your property is going to pass. The other one is generally through a beneficiary designation. That's where you select on the beneficiary form who you want your property to go to. And of course, a last will and testament and a trust. Now, when there's no will in place, how does your property pass? The state. Well, the state doesn't do it, but it's commonly what we refer to as the testate law. That's going to tell you how your property should be distributed. Now, let's just say you've been married and your husband said, hey, I'm going to get a pack of cigarettes. And he's disappeared, and he's been gone for 30 years. And as a matter of fact, he emptied out the account. And you say, you know, next time I see this man, you know, there's going to be a problem. We're going to be moving some furniture around, right? You never get around to divorcing your husband. But during that 30 years, you've acquired a substantial amount of assets. You know, you've saved, you bought a house, you bought things. No children. You pass away. Guess who pops up? Husband pops up, right? You say, hey, look, I'm so here. You know, maybe I need to file a petition and see what I can do to see if I can get this property. So that's the importance of having a will in place. You can disinherit your spouse in Georgia. You can. You can make sure that the beneficiaries are updated on your beneficiary designations for different policies or different retirement accounts. Now, beneficiary designations. Now, you can list the beneficiary designation for your 401k account, most of your retirement accounts, insurance policies, and in fact, you can have what we call a paid on death beneficiary for your bank account. Now, all that means is you may need to go down to the bank, you may need to speak to them and say, hey, look, could you tell me something about listing my daughter or spouse as paid on death beneficiary? You fill it out, and then they'll do that. Now, with beneficiary designations, if you have multiple children and you want to give them a percentage, normally those forms will allow you to do that. You can say 25% to my son, 75% to my daughter. Because while my son was alive, he leaned on me a whole lot. I gave him down payment. I gave him a whole lot while I was living. So you can specifically do it that way. And those that are married, you can have a joint account with your spouse. And that joint account, most of the time, you gotta read the language, will have what we call right of survivorship clauses in that account language. So what that means is if one of the owners of that account passes away, the survivor gets the account. Now, we're gonna give you an example of, we had William. William, as soon as he graduated out of high school, he decided to get a job at the post office. And he got that job, he went in to fill out the new hire paperwork, and on his retirement account, he listed his sister. And he also listed his sister on the insurance policies. Now, 4 years later, around 23, he got married to Ashanti, and he worked at that post office for 40 years. After 40 years, he retired. 1 year later, he passed away. Who gets that insurance policy? That's right. Got some smart people here. So that's the importance of making sure that you update your beneficiaries. And also, when you update your beneficiaries, you can have a contingent beneficiary. Because you might have your spouse as a beneficiary, but what if you're in a car accident with your spouse and you both pass away at the same time? Is there a contingent beneficiary? So those are things that you need to think about. Now, I mentioned joint tenancy with survivorship, and we're talking about folks that are married, and when you're married and you purchase property, you got to pay attention to those deeds. Mm-hmm. And I say that because you can close on the property and it can have both of you listed on that deed, and if there's no language in there that says joint tenancy with survivorship, then if one of the spouses passed away, that spouse just owns 50%. Now, when you get home, if you're married, take a look at deed. If it looks something similar to this, you probably have a joint tenancy with survivorship. Or if that language that's highlighted there, if you see that in your deed, you definitely have a joint tenancy with survivorship. But in that same situation with William now buys a home when he's 25, because he got married at 24, right? Listed, he got a good deal for it in the 90s, right? So when he passed away, of course, that deed did not have with joint tenancy with survivorship. The wife says after he passes that I can't live in this house. It just reminds me of him. I need to sell this house. So she goes to try to sell the house, and the title company tells her, whoa, you can't sell that house. You don't own 100% of that house. You only have a 50% interest in it. You need to resolve this in probate court. So some ways of getting around that is looking at your deed and making sure it has joint tenancy with survivorship language in it. If it's not in there, then you know that's something that you can correct while you are living, right? Now, a last will and testament. There's several benefits of having a last will and testament. First of all, you can say where you want your assets to go. You may want some of your assets to go to your children, but you may want some of your assets to come to the foundation of W.C. Thomas, right? You can elect that. You can say 75% of my assets can go to my children, and the other 25% can go to W.C. I would have said Bay City, Inc. I did. Bay City get 2%. Bay City get 2%. 80% is great. So the other thing is you get to put in there an executor, right? An executor is the person who is going to carry out your wishes in your will. They're going to make sure that that will is admitted to probate, and they're going to make sure that everything is done correctly. Now, the executor, you're going to make sure you pick somebody that is responsible, right? And you're not limited to just picking one person. You can have one main executor, and then you can have what we call the contingent executor. Because you may put, I'm going to list my mom as my executor because I know she's responsible. Mom passes away, right? You never update your will. So make sure you have a contingent executor. Contingent executor will be a person that can step in if that main executor is unavailable or cannot carry out your wishes. Now, a valid will in Georgia. Now, to have a valid will in Georgia, all you need to do is, when you're writing a will, sign it in the presence of two people, and they have to be 14 years or older. Of course, those witnesses cannot be a beneficiary, right? Now, that's important. Now, I always get a call, and I hear a barbershop talk, and it's, I heard that if I write my will on a piece of paper and sign it and mail it to myself, that is a valid will. No. Have y'all heard that?
Yeah.
I've heard that. Yeah. I've heard that. And normally that looks like this right here, right? Right? And that's not a valid will in Georgia, right? I just told y'all why. One sign in the presence of two witnesses. Okay? So if you know somebody that's doing that, you need to tell them, hey, look, you need to go speak to a lawyer and you need to make sure you get your stuff right. Because believe it or not, our biggest asset that we normally hold is our home, right? We get the wealth from appreciation. You know, hopefully you bought at a lower price. You lived in here for a few years. You may have paid $150,000. You turn around, that home may be worth $600,000. You've been working all your life paying off this home, whether you're on a 30-year mortgage or whether you're on a 15-year mortgage. So why would you want to pass on an asset, which is probably your biggest asset, by handwritten a will like this that is not valid? Can we agree on that? Yeah. So trust. Now, this issue, because of TikTok, Facebook, and YouTube, all these videos that we've been getting, I think, probably about 5 calls a week. I want to trust. All these videos on, why you should have a trust and what type of trust you should have. And the truth of the matter is most people do not understand what a trust is. And not everybody needs a trust. You can pass on your assets without a trust. In some situations, a trust is good. But generally, you're going to have 2 types of trust. The first is going to be a revocable trust, which in its name is easily revocable. If you are starting to trust yourself, you're going to be what we call a settlor, and normally you're going to be the trustee. You get to control that trust. You can set up a bank account in that trust name. All you need is your social security number when you go to the bank and the certificate of trust document to set up an account. You can get checks in that trust name. You can transfer property in that name. Now that trust, if it is funded correctly and property is transferred to that trust, the trust property avoids probate court. So that's a great vehicle. Now, the misnomer that we normally have is that it's an asset protection tool. It is not. The revocable trust does not protect your assets. Those YouTube videos that you see, where they're telling you to set up all these land trusts and they're telling you that, you can later on revoke it and transfer. What they're doing is basically titling the trust in different names. So it may be John C. Smith Revocable Trust, and they don't title in their name. So they think if they're sued and somebody does a search on the record, it doesn't show that it's coming up in their name. But this is Georgia. Georgia, we don't have much privacy rights, so a good attorney will see that, hey, look, this property was once in your name and now it's in this revocable trust name. They'll get to the assets of that revocable trust. The second type of trust is an irrevocable trust. Now, an irrevocable trust, as in its name, it's very difficult to change. Normally, the person who is setting up the trust, if you're setting up the trust yourself, you're not going to be trusted over it. That property that's transferred to that trust doesn't belong to you. It belongs to that irrevocable trust. That irrevocable trust is going to have an EIN number, right? If there's an asset in that trust that's producing income, that trust needs to file income taxes, right? It's thought of as a separate entity in some regards. Now, in some regards, there is some asset protection there. But keep in mind, if you are an individual trying to do it for asset protection purposes, a better option would be to get insurance. Just get the right amount of insurance to avoid that. Now, you'll see special types of trust, and these are basically derivatives of a revocable trust or an irrevocable trust. You'll see sometimes what's called a Medicaid planning trust. And folks, when you're around the age of 59 and 60, you're trying to divest yourselves of certain assets because you're going to retire in 5 years. And if something happens to you where you need long-term care and you need to qualify for what we call as Medicaid, each state has its own limits on what type of assets you need to have. And that's what they'll do around that age. You'll also see with the land trust would be a special type of trust. And the land trust, sometimes they'll do it where it's a revocable trust. Yes, sir.
So if you have an LLC currently, should you take advantage of an irrevocable trust? Should it be associated with an irrevocable trust? I guess another one I'm saying, should an LLC owner establish an irrevocable trust?
I don't, if you're LLC, if you have an LLC and you're the sole member, I wouldn't recommend that a sole member of an LLC establish an irrevocable trust. What would be the purpose of establishing it? Because the LLC, you would already have limited liability protection. What would be the reason for doing that?
That's what I'm asking you to tell me.
I got it. So, a revocable trust. Now, that's more common. Now, what we'll see is a person will have a revocable trust, and they'll have the member on that trust, the trustee, and the revocable trust actually owning that LLC. And that's mainly done primarily for if you have a business and you're trying to have that business continue on. So an example of that would be is you have your revocable trust set up. You have an LLC that owns a solar farm in North Carolina, right? That LLC is owned by your revocable trust. In the event that you pass away, that income that's still coming in from that solar plant is going into your LLC. The successor trustee, all they would need to do is show the bank the documents of the trust so they can get access and continue getting paid. Does that make sense? Yes.
I have several questions, but I want to do a backup, and I don't know if you want to continue on before I do backup.
Okay.
Okay, the first one is, what happened, you told us about the husband coming back after 30 years. I want to know what was his benefits? What were his rights to anything that that person, that's what I'm saying.
Yeah, I'm trying to help my colleague out here. And so she may talk about that in the probate process. I don't want to go into the probate process.
My second one is on wheels. What about codicil?
Codicil. Yeah, so that is what we call an amendment to a will.
Right.
Now, that's a good point. What you'll see is folks will scratch out on that will an initial. That's not a valid change. Right? State of Georgia, valid change is, change has to be made the same way it was executed.
Right.
2 witnesses, right?
My third one is, there are several types of POAs, right?
And we're gonna get to the
Okay,
POs.
I'm ahead, okay. Now, my fourth one is, if you pass and you have bankruptcy outstanding, tell me about that.
If you pass and you still owe people, creditors don't go away.
I know they don't.
I'll talk about that.
If you was to have a trust, and in your event that you get, can you leave that same trust to someone else? Or would I have to go to the bank and then close it down?
If you have a trust, can you leave that same trust to someone else?
I was left the trust,
You'd love.
so.
Now, are you a beneficiary of trust?
Yes.
I got you. Now, according to the trust, I don't know the terms of that trust, but was the property outright distributed to you, or?
It was all left to me. I got
Okay, so-
everything.
So a trustee must, the property, must have deeded that property. The trustee must have deeded that property to you.
I got all of that. I'm just saying, if anything happened to me with the trust
That trust, the trustee has
passed on.
done everything that they were supposed to do in that trust. And now the property is deeded in your name. Now you can start your own trust. You'll be the trustee, depends if you're doing a revocable trust. And you can put in that trust who you want your beneficiary to be, or how you want your property to be distributed. So you can certainly, definitely start your own trust.
With that same trust.
No, this would be your trust.
I got the property down.
So the property
You said you have the property already, right?
I have the property
Yes, so
already.
that's your property.
That's
You
yours.
do with that property what you want.
So the trust is null and void.
So I can start another trust.
You can set up your own trust. Yes, sir.
The tax, they charge you tax on that money.
Updating beneficiary. Is it a yearly thing, or is it, if I can update this year, it's good for 4 years and 5 years down the road?
I would say that depends on your situation. So if you know one of your beneficiaries is sick, right? You may want to update your beneficiary right away.
Right.
Because if you're gonna outlive your beneficiary. So it just depends on what's going on in your
There's no
life.
like limit.
You can update your beneficiary as much time as you want.
Okay.
There's no limit.
Did you touch on the special needs trust? Did I miss that? I want to know more about that.
Yeah, so the special needs trust, that falls under what we call the special trust.
Yeah.
And if you have somebody that's a child, that
Has
baby,
special needs.
that has special need, you can set that trust up and make sure that that special child, the child is taken care of.
I wondered if that is what it was. Okay, thank you.
Yes, sir.
Do you set those up?
Special need trust, I do not.
But you know somebody that does.
Of course I do. Any other questions before we proceed? All right, so next we're going to talk about the power of attorneys. All right, so generally what you'll have is a statutory global power of attorney. And then as we talked about before, you're going to have in Georgia Advanced Director of Health. And that basically combines your medical power of attorney along with the healthcare directive. Now, with the statutory power of attorney, in 2017, Georgia adopted what we call a statutory power of attorney. Now, the power of attorney, first of all, it allows you to elect an agent that can act on your behalf if you're unable to. You can give that agent certain powers, and you can limit the powers in that power of attorney. Now, in a common situation you see is, you may have had a father that had a stroke, rushed to the emergency room, they're performing surgery on him, and he is unconscious. His bills don't go away. His financial responsibilities don't go away. You may get a call at the office because somebody has gone to the bank trying to get access to that father's account, and they told him they need a power of attorney. And they call our office and say, "Could you draft a power of attorney?" Once we meet, we'll ask certain questions, and if it's determined that that father is unable to sign that power of attorney because he's not conscious, he doesn't understand what he's signing, then we're not going to draft that power of attorney. So it's a good thing for you to get a power of attorney while you are healthy, while you have your right mind, because that's another call we get. Mom has Alzheimer's, mom has dementia. Mom doesn't know what she's signing. It's going to be very difficult. Now, if you do not have a power of attorney in place, you have to go through the probate court, which is generally a guardianship of the person and conservatorship over their estate, which is going to cost you some money. Now, this is another call I get. I went to the bank, I presented the power of attorney that I copied and pasted off of Google, and the bank has denied my power of attorney. How dare they? What is going on? And that is happening in Conroe now because the banks are training their employees to recognize the statutory power of attorney. So if the statutory power of attorney doesn't look like the statutory power of attorney, it looks like it's Google, copy and paste power of attorney here, chances are they will deny. And that change happened in 2017. They did an update in 2018. Now, the Georgia Healthcare, the Georgia Advanced Directive for Healthcare, that depends on what state you live in. Sometimes they do split these up. And they'll say a medical power of attorney, and they'll also say a healthcare directive. In 2007, Georgia, you'll commonly see, has adopted what we call the Georgia Advanced Directive of Healthcare, which combines the two. It'll grant an agent in there, power of attorneys, to act on behalf of medical issues. And also in that Georgia Advanced Directive, Advanced Healthcare Directive, you can limit the agent's power. You can state things like, I don't want my agent to have the authority to do an autopsy on my body. You can say, I don't want my agent to have the authority to donate my organs. So you can be that specific. Also, you can put in that document whether you want to be buried or cremated. But the more important part of that document is if you have a terminal condition or you're in a terminal condition and your death is probably imminent, you can put in there how you would want the healthcare provider to treat you. Do you want to do not resuscitate in there? Or you can customize in there. And trust and believe me, I'll tell you all a story in a second. That takes the pressure off of your family. We had an aunt that passed last year, and I had to fly out to Dallas. And we were all sitting in the hospital. She had a stroke. The doctor said her brain is 70% dead. The nurses were telling us, have faith, hold on, keep praying. And we were praying. And we had friends that came into the hospital to check on her. And us as a family had made a decision at the time that, we'll take her off of these breathing machines, including to let her pass on. Do you know the friends that came to the hospital started spreading rumors that her family's trying to kill her? You know how much pressure that put on the family? Put a whole lot of pressure. So a decision has been made that, hey, look, you know what? We don't want this pressure. We'll just continue. After 90 days in that hospital, they're trying to kick you out, right? Whatever assets you have is going to pay for wherever you're going, whether it's a long-term care. So the importance of having an advanced, Georgia Advanced Directive is you get to put in there how you get treated. You take that pressure off of your family. So then now your sister or your sons having to make that decision. All right. So that is my presentation. I am here to take any questions. Do you have any questions?
Question for you. So what if with the healthcare directive, are the doctors bound by that? In other words, if a person says, you do everything possible to keep me alive, keep me on the machine for the next 20 years, we'll pay for it, but then the spouse says, no, cut him off. If he cannot, if he brings it, what does the doctor do?
Yeah, so that has been a big problem. And there was a case in Florida where that actually happened. She did not have an advanced directive. The doctors, a healthcare provider, they don't have to accept an advanced directive. Most of the time, they do. Right? So if there is an advanced directive there, generally they will follow the advanced directive. If there is no advanced directive in place, then it'll be a battle in court. We'll have someone trying to get the authority to make that decision. The case in Florida, I think it's a Skyver case.
Terry Shivo.
That's her name. Yes. Y'all know that case, and she passed away. There's been a few other cases throughout the country where a hospital turned that patient down and the families end up transferring them to another hospital only for that family member to pass away.
Okay, please.
Military wills.
A military will. Is that a will that's drafted by a JAG officer?
Yes.
What about it?
Person dies out of country. Let's say person is in the war, person dies. They make you do a quickie will in the process of going over. So they make you do some kind of will before they send you overseas. Person dies over there, whether it's in war or outside of war, friendly or whatever. How do you determine how that will is going to be determined back in the States?
So it depends on where they're resident. So if their residence was Georgia, and they resided in Georgia, that will still has to meet the Georgia legal requirements.
Got another one, but it might be under Stephanie.
Now, the other thing with the will, I'll bring this up because we've seen a lot of this copy paste jobs.
Yeah.
If y'all out there copy and pasting these wills, now I've seen it with social security numbers, date of birth, those are personal identifiers. Why y'all put those in wills? They don't need to be in. If you get a executor that admits that will to probate, they don't redact that stuff. Yes.
Question, so let's say like, talking about the will and executor. What if I have a will in my last will, but I don't have an executor? How does that work? Because now the will won't give a person, charge over what I want them to do. So if I need to have both, it's not just one, correct?
So the executor normally, that's benefits having a will.
I'm saying, so what if I have the will but I don't have an executor?
The executor is who you place in the will. Right, you can write that in the will. Unless it's one of those handwritten wills where you just say, all my property goes to W.C. Thomas, and you sign it in front of two witnesses, and there's no executor, it's a handwritten will like that, then, your family members have to get together and make sure that that's sorted out, right? Now, the benefits of getting your will drafted is you'll make sure that there's an executor that's listed in there. You're gonna make sure you got terms in there that says the executor didn't have to have a bond, didn't have to file inventory. You're gonna make sure all that stuff is in there. And then, if you have a minor child, that's another thing. Do not give property directly to minor children. If you draft in your will, you can put what we call testamentary trust provisions in that will. Now, what that means is, once you pass away, that will converts to a trust at that time. And then that executor/trustee can still carry out your wishes. You don't have that, and you're just leaving stuff to a minor child, that will get tied up in probate until that child reaches majority, which is not ideal, right? There's other ways. If you have grandparents that wish to just leave your grandchildren, which is a minor, money, you can set up a unified minor trust account, right? When you set that up with most financial institutions or insurance folks, you'll be the custodian, the grandpa or grandma, and once that child turns majority, they'll be the owner of that account. But keep in mind, with those accounts, for financial aid purposes, it does count as an asset. Yes, sir.
Any red flags in terms of using some of these software or online programs like LegalZoom to establish your will? Is there anything?
Now, I'm a lawyer, so of course I say bring me all the business, but as I told you, 70% of us do not have a will. So if you're trying to get your stuff done by LegalZoom or legal whatever, I mean, get it done. Get it done. But make sure, if you can, make sure it's done properly. Because some of the disasters I've seen are, they'll come into the office after a relative had passed away, and I am looking at that will that they got from LegalZoom, and I'm saying, witness sign here, see the self-proven affidavit attached to this thing, but the testator didn't sign. Your dad did not sign the will. Son is, well, I didn't know what a testator was. That's like dad is passed without a will. So, should you do it LegalZoom? You can. It just depends on your situation that you got going on. If you have a more complex situation, if you have minor children and you may need to really customize your will, you should probably see an attorney. Right now, the self-proven affidavit, I did bring that up. We had another one, Fulton County, I'm telling you, Fulton County Probate, they catch it. Self-proven will. They can copy paste that will, self-proven affidavit. And look at it, then the probate clerk called, that self-proven affidavit is not good. So what do you mean it's not good? They didn't put in there witnesses have to be 14 years older.
They didn't do what? I missed that.
They didn't put in there that the witnesses need to be 14 years or older. A self-proven affidavit, you have to do, in your area. Interrogatories. Now, and maybe doing those interrogatories may be easier for a younger person. But now if you're dealing with someone that's older, come to your office and the witnesses probably the same age or older, and those witnesses may be dead, that's where the problem comes in.
All right, do we have any other questions for Attorney Clark? Yes, ma'am.
One question. So for these key documents, if they contradict each other, is the will the one that overrides everything else, or like what is the?
Which specific documents have to pass?
So, like the durable power of attorney, the advanced director, if they don't have,
So
they have different information, is the will the one that stands? What's?
No, so they all do different things. So the durable power of attorney is only gonna be good while you're living,
Okay.
right? And that's specifically gonna be used if you're unable to act on behalf of the agent to act at that time, right? Last will and testament, that comes into place once you pass away. That needs to be admitted to probate, so there shouldn't be any conflict there. They're two different documents. Now, in regards to the trust, now, if the trust and the will contradict each other, whatever property that trust owns, that's what it is. And the another thing is, if somebody says, hey, look, I give you this laptop, and you put that in my will, and you no longer own that laptop, and that's it. It's for the laptop.
I have a question.
Yes, ma'am.
A is a will public record versus is a trust public record as well?
No. So generally, a trust is private, right? With a trust or a revocable trust, normally what we'll have is a pour-over will, and then that pour-over will, that would be public record once it's filed with the probate court. With the pour-over will, you'll normally list the main beneficiary as the revocable trust. But the benefits of the trust is the actual trust is private, unless it's litigated. It is private.
And why don't we make this the last question? We want to make sure we give Attorney Shepherd adequate time as well.
Yes, sir.
So if someone were to come to you, they want to settle a will, they want to settle a medical record, what is is there a general cost?
I'm glad you asked that. So the barcode and notes that you have, if you go on that website, I'm transparent on all my fees on there.
It's on a discount.
It's on a discount. Yes, sir.
We're making notes of that.
I'd like a copy of your PowerPoint. Is that possible?
Yeah, of course. I get it, to Worship Master Holloway, and you can get it from him. Or if you want to give me your personal information, or get out of here.
That's fine, you can pass
I
it on
get out
to
of
me.
here.
All right. So, Attorney Clark has another event to go to, so he's gonna break down, and then he may stay a few more minutes, but we're gonna take a 5-minute break, allow Attorney Shepherd to set up, and so, Trek LA, things of that nature. I do wanna, you did a great job, Attorney Clark, and we really appreciate you. I wanna emphasize the important thing is, I know he didn't want to say it, but don't try to do this yourself. I'll say, don't do it yourself. Don't go on to Google or whatever and try to do this. I mean, these folks, and I'm not endorsing either of these two attorneys, I'm not endorsing any attorney, but go to a professional to have the job done. Go to a professional to have the job done.
But I stayed in the Holiday Inn last night, Brian.
Just because your friend, just because your friend is an attorney, it she's the best divorce attorney and she'll give you the greatest discount. Hey, can you do my trust for me? Can you do my will for me? If she's never done that before, she's going on Google just like you. Okay? I'm just being honest. You go to a person who's trained in that area. These are subject matter experts. And there are others in this field as well. Find one of them to do the job for you. Okay? That to me, that's the big takeaway. Thank you, Brother Clark. Really appreciate you. Let's take 5 minutes.
Process and the importance of having the power of attorney, the healthcare director, those things are good for while you're living, and the will. That doesn't come into place until you die. Let me ask you this: how many people in the room have had an experience with probate court?
Nice.
Now, let me ask this question. Did you all approach that process by yourself, or did you all have an attorney to assist you in the process? Attorney. How was that experience for you? Okay, so, and I would expect that, because just depending on what the issues are, it can be challenging even for us as attorneys sometimes. All right, can you all hear me?
Yes.
So probate is just simply the process of distributing a deceased person's assets. So be it a house, a bank account, any type of stocks or brokerage accounts, things of that nature. And if you take Attorney Clark's suggestion and do the proper planning, you've already named your beneficiaries on that stuff, and you don't have to bring those assets through probate court. And that's very important. That's another good reason to do the planning. I'll give you an example. Attorney Clark mentioned that with your life insurance or your 401k, that you named your beneficiaries. And he also mentioned that you needed to update your beneficiaries as things change and update. Because things change, people die. You might get divorced, so it's very important to update those beneficiaries, because just as long as you have an active primary or contingent beneficiary, those assets do not come from probate court. Why is that important? Most people work hard and have invested considerable money into these assets, and the goal is not for these assets to be subject to probate, where your creditors can come in and attach claims and take your money. Because as he stated, the bills don't go away just because you got it. So if you do your planning properly, as Attorney Clark has advised, you won't have that issue, and then your family will be able to utilize the money that you have invested in and worked so hard for. But in the event that you don't, or you don't update, there's a process to be able to help these things go forward. So in probate court, there are various petitions that you will file to achieve certain things. If you have a will, you will file a petition to probate that will in solemn form. So contrary to what a lot of people may have heard, just because you have a will does not avoid probate court. The will is just simply you saying what you want to happen with your property. But in order for your executor to carry that out, they need a court order. That court order would be your letters testamentary that the court would issue to you. And even though you take the time and the energy to prepare this will and express your last wishes and desires, unfortunately sometimes your relatives will not like what you've decided to do with your property.
So they can
You have some that will attempt to rewrite your will for you. And they file what's known as a caveat, or simply an objection to what your desires are. It's unfortunate when that happens, because part of the reason for doing this planning is to be able to transfer wealth. Your house, your life insurance policies, those are your biggest transfers of wealth from generation to generation. And as Attorney Clark stated in his presentation, 70% of people in our community do not have any planning in place. So while the assets are there, you're gonna have to spend money to be able to transfer those assets versus having the planning in place. And then, if that's not bad enough, you're gonna have people that start fighting, which is gonna cost money. Because if you're gonna fight, you gotta be willing to pay to play. It is not a cheap fight, it is not a short fight. So to the best that you can, make sure you have your planning done. Because even if you don't have a will in place, and you have somebody that files what's known as a petition for letters of administration, which simply means that we need an administrator that you got intestate without a will, and the state determines, state laws rather, determine how your assets are divided. Somebody can still fight about that, because everybody want to be in charge. Well, now, I don't want Susan to be the administrator, I want to be the administrator. And like I said, then you move into a litigation phase of it. Another petition that is commonly filed is what's known as a petition for year support. So that is where the surviving spouse and minor children can petition the probate court and say, we need so much set aside for our support for a year. This is very old in Georgia law, and if I'm not mistaken, Georgia is still the only state that utilizes the year support petition. And the concept behind it was when women didn't work, the women and children should not be left to be in a position of being homeless because the husband, who was the primary breadwinner, died. That was the purpose of it back when it was set up. You have people nowadays that try to use it to disinherit people. That's the way that things evolve. But the purpose of it is to be able to provide that spouse and or minor children with support for a year. And just depending on what assets are in the estate, that spouse can take the entire estate and leave nothing else for the remaining heirs. And then we also have what is known as a petition for no administration necessary. It's something that I have utilized before, but not a whole lot, because your decedent or your person that has passed away cannot have any outstanding debt, and all your heirs will need to sign off on the petition agreeing to how to distribute the property. So if you got two siblings and mom has a house, they both agree that we'll take the house 50-50, mom didn't have any outstanding bills, it is a streamlined process to be able to get through probate court, because the probate court will then issue out an order saying that brother and sister own the house, and that order will be recorded in the real estate records. So those are your most common petitions that are filed. I will mention the petition for leave to sell. So let's just say that grandma has a house, grandma does not have a will, and we have heirs that are not in agreement, or we can't find some of them. Let's say grandmama was 100 years old, she outlived all her children, some of her grandchildren died, so we're going down the generations. The more further down that line you get, the harder it is to find people. So the administrator would have to ask the court to allow them to sell the house. That can be a process as well, and it's fine. The one thing that I will say to you, some certain, is that each one of these petitions has a fee to it. Probate court is business. Nothing is free. Let me start right there, because I've spit a lot of information out to walk really quickly. Does anybody have any questions at this point in time?
Let's go.
Well, I was hoping to come away with an answer to the question of how do you avoid going to probate court?
So I'll say this. You can do everything that Attorney Clark instructed you to do. And you still may end up in probate court. Because once,
Document that I can sign prior to.
and even if you create the trust, because theoretically, because like I told you, even if you have a will, you still have to go through probate to probate that will. So let's say you create a trust. You know, the trust is something that's private. It doesn't have to be filed in with the courts. So you avoid probate court like that. But once again, let's say that somebody doesn't like the terms of your trust. Oh, well, Brother Scott wasn't in his right mind when he made this trust. Surely he would not have left me out. Surely he would have wanted me to benefit. They can file an action in the Superior Court, which is even more time and money and process, and contest your trust. I'm sorry, I know that wasn't an answer. However, it is
So I do want to say probate court does work to the advantage sometimes contrary to popular belief. And the reason why I say that is I had an aunt who left a large sum of money to Morehouse College.
okay.
And so it was through, she left lots of money. And so it was through going through probate court just randomly for other aspects of her will that we had uncovered that her heirs could go to Morehouse without paying.
And
so-
and I definitely agree. Like I said, probate court, and that's the first thing I said, it has its purpose. A lot of times people want to avoid it, they don't like it, it's not the fastest thing.
Right.
And like I
It
said,
wasn't
it's-
fast. It was not fast.
And it's money, because like I said, everything is a fee, everything has a cost and or a fee in probate. And like I said, when you got people that are fighting, that extends the process, it extends the cost. Now you have some instances where there's no fight, the family is amicable, and the process moves smooth. But it's the times when they don't.
I've heard the word contest a lot. Can anybody contest my will, or has there a relative of
Your heirs can contest your will.
the heirs? Okay.
So let's just say that you have a wife and two children. And then let's just say that in a previous lifetime, in a previous relationship, you had a And let's just say that in your will, you leave everything to your wife. The children from the previous relationship can contest your will. Now, another tool that your wife does have in the arsenal is that petition for your support, because you can file them together. They're not, one isn't independent of the other. You know what I'm saying? You don't have to say, okay, well, I probated the will, but I'm not going to do this petition for your support. They're two different petitions. So that's definitely an option.
So even his kids, like they're saving and a lot of stuff, the kids can still.
Your kids can still contest this one, yes, absolutely.
Get a lawyer.
That don't stop them from fighting. That don't stop the fight. You gonna Okay, so Attorney Clark mentioned that that's, the codicil is a change.
How do you pronounce that? Codicil?
Codicil.
Codicil.
It's, that's simply a change or an amendment to the will. So let's say you draft your will and you left your mother to serve as your executor, and mom passes away. So you gotta go back to what Attorney Clark told you. You gotta go back and review and update this stuff. This is not, we're gonna do this one time and go put it in the safe deposit box and don't look at it again for another 30 years.
Yeah, that's what I do.
So, on something like that, a codicil is 100% permissible. What I recommend, and Attorney Clark probably will as well, is if you start making substantive changes to the terms of your will, if you're one of those people that change your will every 2 years and you gonna turn around and leave everything to somebody else, you just need to redraft the entire will.
I had a will, sorry, I had a will that I had to prepare. And each, like you said, every 2 years, we updated the will. But in the course of doing that, the will left in it, one of the children, grandchildren, $27,000 on maturity of 21 years old. Okay, that portion was already done. He died, and no one knew that that $27,000 was already given. So what happens with the will and that particular item? What happens then? How does the executor?
So you're saying that the grandchild received the money
Already.
prior to the death.
Right.
So at the time that the grandparent passed away, the money had already been paid.
It had already been, he already dispersed it. Yeah, he already dispersed it, but nobody knew but the preparer of the will. So.
Do we have honest people? Because with documentation, he's already received the money that was promised to him. Now, if they provide that documentation, then like I said, that's already something that's been done.
Yeah.
But if we take your example and tweak it a little bit, let's just say that the grandchild hadn't turned 21 yet, and the grandparent dies, but the grandparent don't have $27,000. And the $27,000 is not in the estate. The grandchild won't be getting the $27,000.
But this long range, the grandparent has more than enough to cover the $27,000.
Right.
So when that person came to them, he gave them the $27,000.
Again?
No, he gave it to them from the beginning. Okay. Once maturity, he gave it to them.
Right.
But he never came back.
That's why
Came back to me and said, take it out. He died.
Right, but this is why it's important to update.
Right.
Say it from one more time, update.
Okay.
That's what I was going to say.
And that's why I say that's why the update is needed. Yes, ma'am.
Let's say that, to keep somebody from contesting, can you leave them $1?
$1, $5.
Yeah.
And if you keep them from.
Right, because you can't tell me what to give you.
Exactly.
You don't get to challenge what I give you. You get the challenge now. If you leave, and a lot of times what people will do, I've seen it in the drafting, is they will say that they provided for, this child or whatever in their lifetime, or they provided for their spouse in their lifetime, because as Attorney Clark said, you can disinherit your spouse here in Georgia. And but like I said, that usually leaves a bad taste, and especially because these are heirs, and you're going to have to get the heirs to sign off on the petition. So the question gets to be, what is the motivation for me to cooperate and participate in this process, and I get nothing?
I ain't participating.
I saw another hand. Yes, ma'am.
Hypothetical. Say the person has property, houses, and in their will, they did designate the houses and this property to the children.
Okay.
The person passes on, but the child's name isn't the children, their names are not on the deeds. What are they gonna do? What's the repercussions behind that?
So,
They never got around to putting their names. The person who passed, their name is on the deeds.
correct.
But in the will, they left the property.
To the
house
children.
To the children,
Right.
but they're not on the deed.
So, and that would actually, for all intended purposes, be the correct process. Because what that person is saying is, just as long as I'm living, this is my house. Now, once I die, y'all can have it, and y'all can do what y'all want to do with it.
It's in the will.
Right. And then once that will is probated, so we gotta go to probate court and probate the will. But once the will is probated, and you bring your publication to your creditors, to give any creditors an opportunity to come and say, hey, you owe me $25,000 and I want my money. If any creditors come forward, you have to pay those, just as long as it's legitimate then, you have to pay those creditors. Now, if, just assuming we don't have any of that, the time period has passed, then the executor can then do what's known as a deed of assent to transfer that property from out of the decedent's name over to the 3 children. Deed of assent. Now, there's some things that are, some tea leaves moving around here in Georgia, where there's actually a bill that passed the legislature that will allow you to transfer your property upon your death. It's called a transfer on death deed. Florida uses it all the time. It's known as a ladybird deed. So if you've heard of a ladybird deed before, that's what this is. Georgia is not as friendly as Florida, so we do things different. But just as long as it can survive, starting July 1, you will be able to do that. And the benefit to that is you maintain ownership of your property in life. And then once you pass away, the property automatically transfers to who you want it to. Once again, keeping it out of probate court. Because if you just transfer on death deed. So this is why a lot of people really try to avoid probate, when you got assets and things like that, because like I said, Big Mama didn't work 30 years to pay this house off for it to go through probate, for her creditors to come and say, Big Mama owe me $50,000, and the only asset in the estate is the house. So then you got to sell Big Mama's house to be able to pay the credit. Yes, sir.
So, when it comes into effect, where do you go file it at? The transfer of
The transfer on death deed, that's a tongue twister, right? We'll call it time. So, once the owner of the property fills out the deed, you would record the deed in your real estate records in the county in which the property is located. I saw somebody right behind him that had a hand there. Yes, ma'am.
Does the process apply to cash liquidity? Like what's held in the bank accounts, that should that be inclusive in
the probate estate? Well, it depends. It depends on how those bank accounts were titled.
Okay.
So if the bank account is in the deceased person's name only,
Right.
that's gonna come into the probate estate.
Okay.
That's why it's very important to do those payable on death designations with the bank. Go into the bank and do it, it don't take 5 minutes. Payable on death. Or sometimes it may be referred to as transferable on death. So either a TOD or a POD.
Okay.
It's quick, it's simple, it's easy. Yes, sir.
So, got the game plan, pre-game plan. So we've got 3 children. I don't want to make any one of them that executor.
That's fair.
What's the process to have an attorney be the executor? It's just a means of retainment, because they're gonna fight about anything anyway. This.
Well, let me tell you something, that's important to know, at least you know that now. Because you know what? In addition to what you have listed in your will, they can object because they don't like who's the executor. I got that case right now. So if you want your attorney to serve as the executor, that would need to be a conversation that you need to have with your attorney. It's not something that's uncommon. Most attorneys are not going to volunteer to do that because they don't want it to be seen as a conflict of interest. They drafted the will. And they don't want the family to come back and say, oh, well, he getting paid, he getting some kind of kickback from this. So, your attorney may be a little reluctant. Don't be surprised if that's the case. If you have a sibling or a cousin or somebody else that you can ask to do it, that you feel like would be capable of doing it, to keep the fight down between the children, then do that. I would say let your attorney be your last resort.
Okay. And my second question is there a process to put in future heirs now in my will without pulling kids, because I know like my father did it when, once my children were born, he filed his codicil and showed me, hey, you get nothing. It goes to them. It's fair. But is there any way, our children have no children, but is there a way for us to put that in now?
A lot of times what I've seen in some drafting is what people would say is if you have children, they would say, I'm leaving my house to my children and my grandchildren or my future born grandchildren. People try to anticipate for that even though the grandchildren aren't in existence yet. That's one way that I've seen people to try to remedy that.
Per service.
There you go, that part.
So I understand the will needs to be in place, the kind of attorney needs to be in place, and so forth. But when the creditors come into play, so when I die and I have an executor, do they reach out to the creditors or do?
That is a wonderful question. So the attorney that probates your will, once the administrator or executor is appointed, that administrator and or executor has 60 days to publish a notice in the legal newspaper to your creditors and debtors. And they'll say, come ye, come all. Now, there's the creditors, they will say, if the deceased owes you any money, bring forth your claims. But the other part of that says, if you owe the deceased any money, come forth. So I haven't seen that part yet.
So this is put in the newspaper.
In the legal newspaper of the county to which the decedent lived in. So for DeKalb County, that is the channel.
Yeah.
And you gotta understand something. You got some of your major creditors or whatnot. This is somebody's job. They're going to go through these legal newspapers to see who's died. So if they file a claim, then, like I said, just as long as it's legitimate. And I know you keep hearing me say, why do you say that? Because if it's something that's uncollectible, you're not gonna come into my probate estate and collect money that you can't collect if you were still living. So old debt, stale debt, you talking about he owed you something from 15 years ago, we're gonna go to court and fight about that. I'm not gonna pay them. So yeah, that would be that process.
So you have to place an obituary or some kind of announcement in this legal.
It's noticed, yes, sir.
I'm asking for a friend. Big Mama property gotta be paid off, correct?
If it's a mortgage on it, yes, ma'am.
And the car is the same way, but the car doesn't have who gets the car because it's still old. So the dealership is the one who gets the car back. Well, the loan company rather.
Well, if you're gonna pay the car off, if you paying the car and you pay the car off.
Big Mama died.
Big Mama
She
died.
left a house, 2 cars, and some other stuff.
Okay.
And they're fighting because they want the house, but the house still has some mortgage. The car still has some.
I don't know if they fight about because they're not paying the mortgage. They don't foreclose. No.
There's nothing to, I mean, they want to go to probate, but they don't know how to go because they still owe stuff.
Well, and that's part of the and like I said, people die every day owing money. You know what I'm saying? Our houses are our biggest investments, and most people can't afford to go and just buy a house.
Right.
But just as long as the mortgage is being paid, so this is going to require for at least one heir to be responsible enough to pay the mortgage. Just as long as the mortgage is paid, the bank will not foreclose. Now, if you don't have anybody that's responsible enough or nobody that has the contact information, because that's the other side of this too, because if you can't access the information, you can't pay what you don't have. Which goes back to what Attorney Clark said about your planning. Something to include in that are your digital assets, because we do so much online now. So make sure you make out a list, with your password, user IDs and passwords and things like that, so that people can access this information. I had a case that came across my desk that I respectfully passed on, The man died back in August. He had absolutely nothing in place. Had a wonderful house out in Fairburn, but the mortgage hadn't been paid since September. And they wanted to fight over who's gonna serve as the administrator. I said, no, thank you.
Explain to us.
Because you wanna be crazy and fight over the foolishness and lose the asset. Yes, ma'am.
Explain to us about if the house grandmama called reverse mortgage.
Oh, you bring up something so important.
Yes, ma'am.
Let me talk to y'all about the reverse mortgage.
So when it did.
Right, so does everybody understand the concept of the reverse mortgage? All right, so make a long story short, okay, so you got a mortgage, you paying the mortgage company, right? With the reverse mortgage, guess what? The bank give you money. You can take it in lump sum, or they can give it to you every month. You like that, right?
No. As long as you can.
Because first off, the bank is not gonna give you 100% value of the property, they only gonna go about 60%.
But they own 100%.
No, you still own the property, just as long as you're still living in it, or your spouse is still living in it, you can go. Now, you got a problem if you die, you got a problem if you go into a facility or nursing home or anything like that, because those documents explicitly state, when you no longer occupy the residence, guess what? The bank coming for that house.
Wow.